Hi, and welcome back to the Histories Inc. podcast. I'm Mallory Nye, and this is episode 10. In fact, this episode is a continuation of the discussion I started in episode 9 on the issues of what is known as the Doctrine of Discovery and the Europeanisation of the land that became North America. Of course, if you haven't listened to episode 9 yet, then I recommend you tune into that episode first and then come back to this one. So the second of factors that I mentioned in the last episode focuses on the papal bulls and the Doctrine of Discovery. You may recall that in the previous episode I discussed the English King Henry VII's claims, his letter patent to the lands of America, which he issued in 1496, which led to the voyage of the Italian John Cabot. When Henry made his claim, both he and the English monarchy were very much within the Catholic religious and political fold. However, by the time that English colonialism in America began seriously, around 100 years after Henry, at the end of the 16th century, England had become a Protestant country. Indeed, as I will discuss in a later episode, England had in fact gone through 3 successive waves of Reformation. By the time that the first English settlers began to attempt to live precariously in America, English colonialism was a form of challenge against Spanish and thus Catholic dominance of the region. This was in some respects why Henry VII's claim of the new lands was so important to the English, since the Spanish had themselves claimed the whole of the American continent for their crown and on behalf of the Catholic polity. That is, to the European colonialists, both of Spain and England, the issue of rights to land ownership and settlement were largely seen in competing claims between themselves, rather than with reference to the indigenous people. Thus, for the Spanish, the New World, and in particular the large territory of New Spain, had been claimed by Columbus on his landing at Guanahani, the island of San Salvador, as it's known today, on the 12th of October, 1492. He'd claimed the lands and established Spanish sovereignty, even though at the time he had no idea exactly where he was, or even that the islands he found on that visit were adjacent to the vast continent that stretched thousands of miles to the north, south, and west. And of course, he'd done so without any thought about the indigenous people, such as the Taino of the islands where he landed. Relating to the Spanish claims of sovereignty and ownership, and also to a certain extent the initial Tudor claim, there was a religious articulation of the European sense of what they were doing, particularly with respect to the people who were already there. The complexities of these ideas are often bound together in the idea called the Doctrine of Discovery, referring to papal statements relating to the new worlds discovered and the people who lived there already. There were, in fact, several edicts and bulls by different popes in the 15th and 16th centuries. In May 1493, Pope Alexander VI, the archetypal Borgia Pope, issued a papal bull known as Inter Caetera, which dealt in particular with the Spanish discoveries in the New World. Thus, the Inter Caetera reads as instruction to the Spanish monarchs, whereby you are bound to our apostolic commands, and by the bowels of the mercy of our Lord Jesus Christ, enjoy strictly that inasmuch as with eager zeal for the true faith you design to equip and dispatch this expedition, you purpose also, as in your duty, to lead the peoples dwelling in those islands and countries to embrace the Christian religion. Give, grant, and assign these lands to you and your heirs and successors, for ever, together with all their dominions, cities, camps, places and villages, and all rights, jurisdictions, and appurtenances, all islands and mainlands found and to be found, discovered and to be discovered. As I've said, this was one of several such bulls, issued during the early years of European expansion in the new American territories. Together they established the legal right of the Spanish and their heirs and successors to not only promote Christianity to the native people of these territories, but also to rule over those people and to take their land. And of course, this is exactly what the Spanish and other Europeans proceeded to do. To make this land acquisition by discovery more official and sanctioned, Spanish colonialists arriving at new territories in America were required to read out to the native people a document called the Requerimiento that included the following instruction to them. Of all these nations, God our Lord gave charge to one man called St. Peter, that he should be Lord and superior of all men in the world, that all should obey him, and that he should be the head of the whole human race, wherever men should live, and under whatever law, sect, or belief they should be. And he gave him the world for his kingdom and jurisdiction. One of the successors to St. Peter as Lord of the world, as Pope, donated these islands and the American continent to the Spanish king and queen, and to their successors, our lords, with all that there are in these territories, as is contained in certain writings which passed upon the subject as aforesaid, which you can see if you wish. This Requerimiento document was read out in Spanish by the colonists, usually with no effort to translate into the language of the recipients, and often to empty beaches, or even on the open deck of the ship as it made its approach to the territories. The document ended with a warning. We therefore ask and require you that you consider what we have said to you, and that you acknowledge the Church as the ruler and superior of the whole world, and the high priest called Pope, and in his name the King and Queen our lords in his place, as superiors and lords and kings of these islands, and this continent by virtue of the said donation, and that you consent and give place that these religious fathers should declare and preach to you. But if you don't do this, I certify to you that with the help of God, we shall powerfully enter your country, and shall make war against you in all ways and manners that we can, and shall subject you to the yoke and obedience of the Church and of their highnesses. We shall take you and your wives and your children, and shall make slaves of them, and as such shall sell and dispose of them as their highnesses may command. And we shall take away your goods, and shall do you all the mischief and damage that we can, as to vassals who do not obey, and refuse to receive their lord, and resist and contradict him. And this is why the seemingly obscure Inter Caetera Bull continues to be important and relevant to the world in which we live. It helped to make today's world, and quite surprisingly, it remains as a tenuous legal justification for European ownership of American lands. This is most evident within the US legal system, and in particular the central place of a judgment made in the US Supreme Court in 1832, in a case titled Johnson v. McIntosh. This case related to different claims made by white landowners related to a piece of land that had been acquired from Native Americans. In his judgment, John Marshall made explicit reference to the sources that I've mentioned already, that is, the Inter Caetera Bull, and also the commission given by the English King Henry VII to the explorer John Cabot. The key question of the case was whether indigenous American people, called Indians by the European Americans at the time, had the legal right to sell land. The counter to this was that land ownership in America, specifically the USA, was held by the state, the nation, by virtue of its inheritance of sovereignty over the land from the British Empire prior to the American Revolution, which in turn had acquired that sovereignty due to the granting of the land by English monarchs, particularly King James I and King Charles I and Charles II. In short, Marshall found in favour of the latter argument, that land ownership was based on the US's historical inheritance of sovereignty from the British. To quote him, "The rights of the original inhabitants were in no instance entirely disregarded, but they were necessarily to a considerable extent impaired. These inhabitants were admitted to be the rightful occupants of the soil, with a legal as well as just claim to retain possession of it, and to use it according to their own discretion. But their rights to complete sovereignty as independent nations were necessarily diminished, and their power to dispose of the soil at their own will to whomsoever they pleased was denied by the original fundamental principle that discovery gave exclusive title to those who made it. While the different nations of Europe respected the right of the natives as occupants, they asserted the ultimate dominion to be in themselves, and claimed and exercised as a consequence of this ultimate dominion a power to grant the soil while yet in possession of the natives. These grants have been understood by all to convey a title to the grantees, subject only to the Indian right of occupancy. The history of America, from its discovery to the present day, proves, we think, the universal recognition of these principles. Conquest gives a title which the courts of the conqueror cannot deny, whatever the private and speculative opinions of individuals may be respecting the original justice of the claim which has been successfully asserted. The British government, which was then our government, and whose rights have passed to the United States, asserted a title to all the lands occupied by Indians within the chartered limits of the British colonies. It asserted also a limited sovereignty over them, and the exclusive right of extinguishing the title which occupancy gave to them. These claims have been maintained and established as far west as the river Mississippi by the sword. The title to a vast portion of the lands we now hold originates in them. It's not for the courts of this country to question the validity of this title, or to sustain one which is incompatible with it. The title by conquest is acquired and maintained by force. The conqueror prescribes its limits. That's the end of the quote. That is, in a nutshell, Marshall's argument was that the European states, the crowns of England and Spain, had taken legal possession of the American lands on their discovery, in the absence of any rival legal claims, and then subsequent seizure by conquest of the lands. And later the sovereignty of that possession had passed to the United States at the time of independence. That is, as the law could not be in a position to challenge the sovereignty of the state, so it could also not challenge the means by which that state acquired its lands. The initial lie of making the legal claim that these lands are ours to take could not be declared as such, otherwise it could undermine the basis of the country. Largely for this reason, Marshall's judgment has remained intact, and has been put to use, mostly in relatively minor contexts, as recently as 2005 in the case of the city of Sherrill, New York, versus the Oneida Nation. Neither Marshall's judgment or the original bulls have been redacted, despite increasing calls for this. As a number of commentators have pointed out, Marshall's own historical understanding of the basic facts was itself flawed. Indeed, there have been a number of historical claims against this viewpoint. In the case of Spain, this happened very early on. For example, the Dominican Bartolomé de las Casas wrote a number of works against the dehumanizing of the Native American people by the Spanish colonialists, based on his first-hand experience in the new colonies, firstly as a colonist himself. Theorists in Spain, such as Francisco de Vitoria and Hernando de Soto, even challenged the idea of claiming legal ownership of the indigenous people's lands. And, as mentioned in the last episode, early on in the English settlement in Northern America, in Plymouth and Rhode Island, the Puritan Roger Williams refused to accept the assumption that land could be taken from the Native Americans without some form of transaction. Although his was a lone voice among the English, the Dutch settlers famously did proceed to purchase their lands, most famously through the exchange of 60 guilders of goods, around $1,100 in today's money, for the island of Manhattan. As the commentator Blake Watson notes, this issue is at the root of nearly all real estate in the United States. It is an incredible thought that the legal chain of documentation for most land ownership in that vast country ends in an act, most likely long buried in history, where the land was claimed and taken by European settlers, without any due consideration for the native people's ownership of that land. It is a messy state of affairs, and one in which there is no simple solution. It probably lies beyond the power of any US president to fairly address the issue of the historic land seizure, as implied by Marshall's judgment. To do so would be tantamount to denying the United States' own sovereignty. But it is a conversation that Americans are having with themselves in various ways. This is largely, of course, being led by indigenous American groups, who have tried to challenge the historical political settlement in the US and other American courts, as well as through the United Nations. The exploration of the issues has been most prominent so far in Canada, perhaps most notably in the context of the Catholic Church. Thus, members of the Canadian Catholic Church have been lobbying the current Pope Francis to officially revoke the historic doctrine of discovery. Indeed, in March this year, in 2016, a range of Canadian Catholic organisations issued a joint statement that, to quote them, considers and repudiates illegitimate concepts and principles used by Europeans to justify the seizure of land previously held by Indigenous peoples and often identified by the terms Doctrine of Discovery and Terra Nullius. In short, these groups, although not formally the Catholic Church or the Pope, have repudiated this historic idea of the Doctrine of Discovery. However, the ideas behind this doctrine, along with the claims of sovereignty based on the patent going back to the English King Henry VII, are all still very much alive. Politically, the Europeans have successfully held ownership of the lands on the basis of these claims. The historical development of these claims, however, is considerably more complicated. So, thanks for listening to these 2 episodes on the Doctrine of Discovery. I hope you've been able to follow the argument and ideas through the break between the 2. If you haven't done so already, you can find out more information about this topic on the Histories Inc. website, which can be found at histories-inc.com. And if you like this Histories Inc. podcast, and you're in a position where you'd like to give some small support to it, then you can also pledge a small donation to help me with the running costs through the Patreon website. That's Patreon, patreon.com/Mallory9. And of course, if you're listening to this on iTunes or Stitcher, don't forget to subscribe for free to the podcast to make sure you don't miss future episodes. And if you like the podcast, then do please leave a review. It helps other people to find the podcast. That's all for today. I'll see you again soon. Bye for now.